So what are the possible consequences for employers if they mishandle applications for flexible working?
Well, first of all, looking at the internal steps that are available, irrespective of whether or not there's been an appeal stage included, if the employee is unhappy, then they've still got some further, there's still further steps in the internal process. For example, they can raise a formal grievance, which would then need to be processed under the employer's grievance procedure. I suspect what you're really asking is what happens when it really goes wrong, and we move out of those internal steps.
Exactly.
Now, if the employee has generally failed to handle the application properly, an employee can make a claim to the tribunal under Section 80H of Section 80H of the Employment Rights Act 1996. Now, there are 4 claims that you can make under that particular legislation. The first one is that there's been a failure to deal with the request in a reasonable manner, which we've touched on in the previous questions. The second is that there's been a refusal based on impermissible grounds. So if you've refused it on the grounds of something that wasn't one of those 8, the most common one is don't want to open the floodgates, don't want to set a precedent, not a permissible reason. A refusal based on incorrect facts. Now, this is one of the reasons why there's a huge benefit to having that discussion with an employee when they make the application, because you're going to be able to establish what the applicable and correct facts are. And the fourth one is failure to notify of the decision within the prescribed period, which is the 3 months or extended by agreement. Now, if the claim for one of those succeeds, the tribunal is going to be able to award compensation of up to 8 weeks' pay, which is capped at the statutory maximum. And they can also order that the employer revisit that application. What they can't do, interestingly, is make any order to direct the employer to then agree to that request. Where it gets a bit more complicated is that when this has been mishandled, it can also give rise to other claims, for example, direct or indirect discrimination based on protected characteristics such as sex, age, disability. With regards to disability as well, it's quite common to see disability claims that are attached to flexible working complaints that make reference to a failure to make reasonable adjustments. And the other thing is, even if you set that aside, if the manner in which you've dealt with the application isn't reasonable, and perhaps you've not adhered to internal policies as well, then you could be looking at something that amounts to a fundamental breach of contract on the part of the employer, in which case that would entitle the employee to resign and claim constructive dismissal. So there's quite a lot can go wrong, really.
Absolutely, and that's why I suppose we thought this would be a really interesting topic for many.
Just before you move on, Tom.
Yeah, I see there's a question.
Yeah, David's asked a question there about, do we have to substantiate the 8 reasons for refusal with evidence? And Cheryl, I'm sure you'll correct me if I'm wrong, but certainly whilst there's no legal requirement to provide evidence when you're giving the reasons to the employee, obviously if you're later challenged in court, you're going to be in a much better place if you've got that evidence to support it. So certainly looking at, if it's around additional costs, what would those additional costs have been? If there's been a detrimental impact on your customers or your ability to meet your business demands, having that evidence to support it, if you challenge on later, would obviously help in terms of sort of making sure that you're in a better position later on. Cheryl, what's your view on that?
No, absolutely agree. And actually, if you take that example that you've given there with the additional costs, so additional costs is a permissible reason, but in order for you to know there are additional costs, then you're going to have gone and you're going to have looked into that. And if you just make these decisions without looking into them, then what you actually are risking is that you're going to decide it on incorrect facts. So you may assume there is an additional cost, but actually if you dig deeper, there might not be. So you don't necessarily need to put those reasons to the employee at the time, but you're going to need to have them and you're going to need to be able to back them up, because otherwise you're going to get the incorrect facts argument. And I suppose the other thing being is that if you give the information to the employee, there's a better chance the employee is going to understand the rationale and not go through these additional steps. So from that practical purpose, sometimes it's perhaps not always wise to give all the information, but certainly some of it when you proffer in one of these reasons for refusal.